What's up, everybody? Welcome in to a jury conversation here. Another conversation where we can learn from each other about societal interests. How should it be? How is it going to be going forward? Is this new age of trials and publicity and media really focused on true crime in these cases? Is it a good thing? Is it a bad thing? We're going to discover that today. We're going to discuss it today. We're going to answer questions. We're going to read through the motion regarding jury misconduct in Ashley Benefield's case. And we're also going to discuss Alec Murdaugh's big win in the judicial system about issues with their jury, potential misconduct from the jury, from the clerk, and how that's going to affect his case, and how this is going to be precedent set for all sorts of cases, especially high profile ones coming in the future. So hit that like button. Make sure you subscribe. This is going to be a good one. So we're going to read through this motion, but before we do, I know there's a big question on everybody's mind, and it's on my mind as well. This is happening all the time. And how often did it happen in the past? A lot of people are asking me, and my answer is not very often. It does happen from time to time, and especially the second part of this motion to interview jurors, the second part of this has actually happened quite a few times, so much so that in our civil rules meetings for the Clearwater and the St. Pete Bar Association, we have done specific CLEs, continuing legal education, on how we deal with jurors not being truthful. It happens all the time that jurors are just not truthful in voir dire, and it's such a problem. And we saw it recently in the Ghislaine Maxwell case, where a juror just outright lied about their past with something that was very prevalent in the case that they were a juror on. And the lawyers would have asked more questions. That's kind of part two. But part one focuses on publicity with the trial, jurors leaking information, jurors potentially sneaking phones in there. We've seen these types of allegations in the Take Care of Maya case. We've seen it in Karen Reed, Murdaugh, other different kinds of juror misconduct allegedly in those other cases. We have yet to see it go far enough to overturn a case, but we have seen it go far enough to grant juror interviews. And we're waiting in Karen Reed's case, not necessarily juror misconduct, but misunderstandings potentially with the juror. Will that go far enough to give a juror interview? In Murdaugh's case, it went far enough for juror interviews. So this is happening more often. Is it a good thing? Is it a bad thing? Is this live streaming and this attention a good thing or a bad thing for our judicial system? Is it good or bad for justice? Because that's what we care about. And when we say good or bad for the justice system, what we mean is good or bad for justice. Convicting the defendants that did it, giving the victims justice. For the defendants that didn't do it or the state doesn't have enough to prove it, they go free. That is justice. So let's take a read. And with that in mind, that's going to be one of the focuses of the discussion today. Motion to interview jurors. Ashley Benefield, by and through undersigned counsel and pursuant to Rule 3.575 of the Florida Rules of Criminal Procedure, in conjunction with, as part of her motion of new trial, hereby moves the court to conduct interviews of the jurors in the instant matter as grounds of support of the requested relief. Ms. Benefield submits the following. So I can't tell whose watermark that is, but I don't know. Something Tracy, John sent this to me. Somebody sent it to him. So thank you for the people that sent it. This one blocked out the juror names. It is public information. A lot of the information, I think all of the information they put in this motion is public, but whenever we can get the opportunity ahead of time to block this stuff out, we will. We're not always able to. And again, it is public, but we're going to block their names out. On July 30th, 2024, the jury rendered its verdict. Evidence has come to light indicating that the verdict may be subject to legal challenge due to juror misconduct. This alleged misconduct not only violates the court's explicit instructions, but also infringes upon the defendant's constitutional right to a fair trial and impartial jury, and subjects the verdict to a legal challenge. During jury deliberations, a YouTube user named That Hoodie Guy posted comments on the Law and Crime Network's YouTube live stream of the Verdict Watch. These comments contained real-time information that could only have originated from within the jury room, suggesting a breach of the court's instructions, the sanctity of the jury deliberations, jury sequestration, and Ms. Benefield's right to a fair trial. So let's break that down for a second. So again, if I was going to compare the first part of this motion to any of the other objections, I would compare it more towards Johns Hopkins juror misconduct motion and less like Murdaugh's and Karen Reed's and Ghislaine Maxwell's. It's more of this could only have come from inside the jury room, as if it could not be either A, an online troll, B, and I'm not calling this person a troll, I'm just giving the other options, B, somebody who was just following the trial and guessed or had an educated guess as to what's going on in there and acted like they knew more information than they did, or C, someone who was just purely blowing smoke and someone who was not telling the truth, or lastly, it could obviously be exactly how they're stating it. But they say, based on the context and what was said by that hoodie guy, it had to come from inside the jury room. So let's get into the context here. The comments posted on July 30th, 2024 reveal at 10:20 p.m., 10 minutes before the parties were notified that the verdict had been reached, that hoodie guy posted a comment stating, "Verdict incoming." Okay? I will just tell you from my experience, this may be true, this may be correct, this may be accurate. But I had people in my DM saying, verdict reached a million times when it was not actually reached. Okay? That's number one. Number two, at 10:25, that hoodie guy posted a comment stating, per sources, 5-1 guilty with the man stuck on not guilty or manslaughter. So first off, that's not good for the defense if that's true. But number two, this could also be blowing smoke, guessing, or of course, true, that he was getting the information from the inside. At 10:27, that hoodie guy posted a comment stating, "My sister snuck a flip phone in." Not good. If true, bad. Also might not be true. At 10:28, that hoodie guy posted a comment stating, "I am the brother of one of the jurors. She just texted me this. Per sources, 5-1 guilty with the man stuck on not guilty or manslaughter." So the reason I brought up potential troll is repeating the same thing over and over again to try to get attention sometimes is an indication of an internet troll. I'm not saying that's what this person is. I just think that we have to be open to that possibility. Okay? And people are saying, I remember him saying this. Okay? And nobody's going to dispute that he said it. I think they have screenshots and stuff that they attach to their motion. But is it true is the big question. At 10:30, a mere 2 minutes after that hoodie guy posted that the jury may compromise on manslaughter. First off, he did not say, at least here, that the jury may compromise. He said, 5-1 guilty may compromise on manslaughter. Okay, so sorry, this was different. Man stuck on not guilty or manslaughter may compromise on manslaughter. My bad, I misread the second time. So 2 minutes later, the jury returns a compromised verdict of manslaughter. Okay? A lot of people were potentially saying that, right? A lot of people were saying they might have a compromised verdict. The timing and specificity of these comments, followed by corresponding jury actions, strongly suggest that hoodie guy's information originated from within the jury room during active deliberations. This represents a breach of the jury's sworn duties and impacts the fairness of these proceedings, subjecting the verdict to legal challenge. So let's break that down for a second. Number one, this attorney is correct. If this is true, this could be a major problem. Now, you'd be smart if you asked, it was 5-1 guilty on the higher charge. So who cares? Why does this matter? The defense was going to lose either way. And while that may be true, Watermark is seeking justice. Okay, I don't know if that's a specific person, but thank you to Seeking Justice. So it doesn't necessarily have to be that they were all going to vote not guilty. That's why I said it's not the same thing as Karen Reed. But if people were commenting and contacting the outside world and having people post on YouTube, were they engaging with media? Were they following this stuff? It just opens up more questions to see, were they affected by outside sources or outside pressure to vote a certain way? Did they make sure this guy that was going to vote not guilty, they pressured him into voting manslaughter? Whatever it may be, they need more information. And if this stuff is true, then I think they've got a pretty good argument for a potential juror interview. But let's keep reading. The alleged misconduct raises serious concerns about the integrity of jury deliberations and the reliability of the verdict. Specifically, it raises questions about a juror smuggling an electronic device into deliberations, which is not permitted in the jury room. That right there would be jury misconduct. Real-time communication of confidential jury deliberations with non-jury members, misconduct. Influences external to the evidence presented during the trial may have influenced the verdict. Again, need more information. Access to unauthorized materials affected the verdict, potentially. The overall integrity of the fact-finding process being compromised. The prompt removal of these comments from the Verdict Watch on Long Crimes YouTube channel live stream further underscores the seriousness of this potential juror misconduct. So they were removed later. The cover-up is often worse than the crime, or at least evidence of the crime itself, right? Some consciousness of guilt, potentially. Okay, so that's it. And we'll stop right there for a second to talk about, is this getting worse? Okay? The deputies are pretty on point when it comes to taking cell phones. Correct, but I also know that if you were going to hide it somewhere that a deputy is not going to search, or if you give your cell phone and you have it, in an under pocket or inside your pants or something like that, it's probably possible to sneak it in, but not guaranteed, right? I don't feel like there's a ton of evidence that this is true. I feel like it may be true. And what do we do when we really get to this point? And again, comparing this to Karen Reed, a much different ballgame. Comparing this to Alec Murdaugh, a much different ballgame. From my perspective. If the judge does not order that there's enough here for a jury view or a jury interview, I understand that. Because can they even corroborate who that hoodie guy is? Because if you remember in Maya's case, they do get to the jury interview, but they were able to corroborate, and it was open notice that this was the juror's wife. And the juror himself went online publicly and said, I am juror number whatever. I think it was number 1. Do we have any of that confirmation with the hoodie guy? Johanna Kate said, we all need to do better. Honesty on the questionnaire and following instructions. Take the duty of being a juror on the jury, a public servant, seriously. So I'm going to hold the second part of the question for when we read the second half of this motion. But for the first half, let's talk about that for a second. So doing our duty and taking it seriously, and all of this heightened media attention on these cases, okay? And Jenna said, I believe that people are too addicted to social media. Okay, fair. So here's what I'll say. I truly and fully believe. So one of the other things, sorry, I'm switching course here, but people say money doesn't change people. It just amplifies who they are, something like that. And I kind of feel that way about social media sometimes, or even situations like this. And I feel confident that this stuff coming out is likely to have happened on other juries, but just nobody ever found out about it because there was no social media, because there wasn't as much access to jurors. Now, I think it's a combination. I think potentially the misconduct percentage, if it is going up, it's not going up as much as it seems like with all this stuff out there in the news. But I also think opportunity for misconduct is going up. And that might be the issue that we've got to discuss and figure out how to best handle with rules, with the court system. And Rebecca said, again, I've been on juries, metal detectors in SM cases. So metal detectors usually in our court systems is in the front, which you're allowed to bring your phone through, and then you give up your phones when you go into deliberations. I know for a fact that at least some of my juries have not gone through a metal detector again after handing over their cell phones. But I think it's important for us to remember that this opportunity of misconduct may be going up, but jurors that are willing to do the wrong thing and not follow the rules has always been there. And I've always been a proponent of, if shady stuff is going on, let's shine the light on it. I'd rather know if misconduct is happening rather than it happening and us never knowing, because there is no media, because the public doesn't care, because the public isn't interested what's happening in their court system. And that's where shady stuff can happen and people get railroaded and outside influences can come in and we just never know about it. And it never stops and it gets worse. So I'd rather know about it. I'd rather fix it. I'd rather figure out a way to do it right. Not than pretend like it's not happening, because I think it is. Reese's mom said, really, there wasn't one honest juror who saw that and advised the court. So again, that could be a possibility. Or they go to the bathroom and text their brother on the phone that they know they're not supposed to have. So maybe no other jurors knew about it. Again, not a ton of information. Jill, don't they have signal disruptors in deliberation rooms? I would think that would be standard. I don't know. It's a good question. Not something I've ever asked. I don't know. Kelvin, thank you for covering. Admittedly, I cling on to my past experience as a juror from a decade ago, when I conclude a person's guilt when I watch present trials. That's fair. It's totally fair. And I appreciate you coming into this knowing that. And we can know that that's a filter we got to deal with. Rebecca, how did the other jurors not see this? I think that's possible because they're allowed to take bathroom breaks, go to the bathroom, snack breaks if they eat. They're not always right next to each other. Now, maybe they did see it. I don't know. And maybe we'll find that out. So let's move on to the more concerning. So if I'm going to compare these two, this is the less concerning. This potential juror misconduct is the less concerning of the two, because I kind of believe we could find out this is true. That juror may be sanctioned because bringing a cell phone in there could be a major problem, but did it really affect the verdict? Reporting what's happening inside the jury room cannot happen, should not happen, absolutely should never happen. If any lawyer or bailiff or clerk was involved in pushing this, they should be reprimanded. There should be, sanctions coming. But if it was just this one rogue juror that brought in her flip phone and texted her brother what was going on, I'm not sure that'd be enough for a new trial. I don't think it would be, honestly. But we move on to the much more concerning issue of juror misconduct. This happened in Ghislaine Maxwell. It's happened in some other cases we've covered. It's happened in some cases I've had, and it's happened to some close lawyer friends of mine who I've tried to help deal with and write motions and fight this stuff. Because once a verdict happens in a civil case or a criminal case, it's so hard to win on appeal. And we take so much time and energy and effort. And I talk about it all the time on this channel. And I feel like you guys have helped me so much pick juries. You've helped me talk to juries in voir dire, figure out what they want to know, what they don't want to know, what they think is BS, how we break down some walls, how we build up some trust. That's incredibly important. It's the most important part of trial, in my opinion. But when this happens, it pisses me off. I got to be honest. It pisses me off. It seems like this is true, right? I feel like they've given us enough information to think that these next allegations we're about to read are true, and it pisses me off. We've got so much time and energy and effort and liberty and life and money and resources on the line here. We've got the victim's family and their heartache. We've got the defendant's life and liberty. We've got all the lawyers and bailiffs and clerks and witnesses and judges taking time and money out of their day to do this as their job or be a witness on this case. And for somebody to just blatantly, flat out lie about their background and information to not allow the lawyers to ask the questions cannot happen. And this, to me, if this is true, this should be enough to overturn the verdict and hope that jurors do not do this in the past. They should be sanctioned. I'm sorry. I love jurors. I love them. And it's a big civic duty and it's a lot of time taken out of their lives. And I don't take that lightly. And I appreciate that so much, but this is unacceptable to me. Let's read it. In addition to the above, evidence has come to light indicating that the verdict may be subject to legal challenge due to juror 15 being untruthful during voir dire by falsely representing that she had not been a victim of a crime, her son had been charged with a crime, and she had involvement in child custody, domestic violence, abuse matters. So they're accusing her of lying, meaning saying, no, she didn't deal with all of this. And why is that important? Because follow-up questions, especially a case dealing with these exact issues, you can expect a ton of follow-up by the lawyers. Juror 15 completed a jury questionnaire under penalty of perjury, which asked, have you or a member of your immediate family been the victim of a crime? Juror 15 responded untruthfully to those questions by omitting that, one, she had been a victim of a crime, battery, domestic related, on February 20th of this year, of a year that's blocked out, when her live-in boyfriend, name blocked out, intentionally slapped her in the face with an open hand 5 times, and 2, that her son had been charged with felony battery against his pregnant girlfriend on August 31st, for which Juror 15 posted the bond. So she knew about it. On March 18th, Juror 15 of a certain year, Juror 15 filed a petition for injunction for protection against domestic violence against Mr. Whoever in the 12th Judicial Circuit in Manatee County, case number whatever. The allegations of the latest act of violence or threat of violence provided that blank grabbed her by the hair and repeatedly hit her in the face, causing a black eye, damage to the inside of her mouth, and a swollen face. So before we go through that paragraph, yes, this juror was on the jury. So let me explain kind of how some of this works. Number one, lawyers need to know this information for some obvious reasons, but I think some people may say, seems like she might be good for the defense, right? A battered spouse. That's what Ashley Benefield was saying she was, a battered spouse. Well, number one, lawyers always want to do follow-up questioning, right? If something exists, we want to ask questions. Because I will just tell you, as a lawyer that has practiced in prosecuting cases in trial and defended the accused in criminal cases, just because someone had a similar experience with your client does not make them a good juror for you. For example, if you know that your client accused Doug Benefield of hitting her in the face and she has minor injuries, maybe injuries that might not be obvious in a picture, maybe you don't want someone on the jury that you think is only going to believe that domestic violence happens if you are in the hospital after an event. It's kind of like trying to explain to somebody that drinking and driving is not illegal. When your blood alcohol level is over a certain amount or your normal faculties are impaired, it's illegal. But having a beer and driving is not illegal. There are some people that just cannot agree with that, can't go forward with that. So just because somebody has a similar experience doesn't mean you're necessarily going to want them as a juror in your case or think that they're a good juror to sit on your case. But the point is, the lawyer is entitled and the defendant is entitled for their lawyer to be able to ask follow-up questions, which they were not allowed to do in this case, which takes away effective representation, which is a constitutional right for every accused. Juror 15 was a respondent in a petition for injunction for protection against domestic violence filed on September 2nd by her ex-husband. This means her ex-husband actually filed an injunction against her, seeking protection for himself and their minor child in the 12th Circuit Court in and for Manatee. Juror 15 was threatening, this is the accusations, being threatening and violent, including cussing, slamming doors, threatening, and throwing things at him. He requested that his son come stay with him until Juror 15 can get some help. She attempted to hurt herself and was hospitalized on July 18th. She called and told the ex-husband that she was going to hurt herself. Constant harassment and threats to his wife and himself. Her ex-husband feared that Juror 15 might try to hurt the son along with hurting herself and requested to keep his son until Juror 15 as well, specifically requesting visitation until Juror 15 supervised visitation till she showed she was stable mentally and financially. So is any of this true? I have no idea. And we are not here to litigate this case. We are not here to be the judge and the jury of these allegations. Is it true? Is it not true? I don't know. Juror 15 could be a wonderful person who never did any of this, but family law got ugly and her ex accused her of these things. Or she could have done some of it, not all of it, or she could have done all of it, right? We don't know the answer to that, but we don't need to know the answer to that to answer this question. This is kind of how law school teaches you how to think. Get rid of the red herrings, move everything out. When you read this, you start to think, wow, Juror 15 must be really bad, or Juror 15 must have done this. We don't need to figure that out. That is not important in our analysis. What's important in our analysis is, did these allegations happen? Are these cases legit? Seems like they found them in the public record. And if they are, why did she lie about them on the jury questionnaire? Because if all this is BS, she could say, yeah, my ex-husband, was trying to get money from me, or he had mental health issues and he accused me in retaliation for me accusing him. And guess what? That may be true, that may not be true, but we as the lawyers get to ask the questions, we get to get the answers, then we get to make our decision based on the information we have. Do we want to strike this juror? Do we not? Do we want to strike her for cause? Meaning there's no way she can be fair. Judge, hey, too many things that are similar or different that we think are going to come in. The judge may have struck her, and if not, we can use a preemptory to strike her. But we have to have the opportunity to do that as lawyers. I meant to talk about this, but kept forgetting. RJ asked, do they do background checks on juror answers? So, depending on judges and jurisdictions, you can do some research on jurors. Sometimes that'll include background. Sometimes it'll include some public record searches or social media, but you don't always find everything like that. You got a million things going on. Some judges don't allow you to, like in federal court. And sometimes it's harder to find these things. You can't just pop in, Sam Smith and everything pops up. You got to do a little digging sometimes. And sometimes that's hard to do during trial. People pay jury consultants and companies thousands and thousands of dollars to do jury research sometimes. How do attorneys find these things out about jurors lying after the fact? Do they get their names and then search out court cases to see if anything flags? Yeah, and sometimes they do it before it happens. Also, one of the other thing about the high profile nature of these cases, the public interest, the media, sometimes you have people on the outside world saying, hey, did you know this about juror 15? I don't know how they got it. I want to be a pro-jury member, Crystal B said. The question asks if a victim of a crime, shouldn't it be clarified to a victim or charged or being charged? So I haven't seen the full jury questionnaire, but my guess is it was one of the standard ones that says charged, accused, victim. Have you ever accused? Close family members. Usually we ask all those kinds of questions. And I would be willing to bet that in the verbal voir dire, because there are written questions in the questionnaire, but also the lawyers get up. And by the way, all the potential jurors swear to tell the truth. They answer their questionnaire penalty of perjury, but also swear in court to tell the truth and answer these questions honestly. And I can almost guarantee, I didn't watch voir dire, but I can almost guarantee the lawyers ask some of these questions. Probably both sides lawyers ask some of these questions when picking the jury. Peter, I think, yes, more opportunity, but also I do believe people's morality has lessened, and this also contributes to more misconduct. Right, but if their morality is going down, that has nothing to do with the media, right? I mean, that's just happening generally if that's, something that you believe, I would think. Question asked victim. Oh, sorry, we already read that one. Terry, it's a double-edged sword, isn't it? It's good to get exposure on the one hand for a rogue juror, and I'm sure this doesn't happen often, but it equally damages the whole process and legal integrity. So I don't know if it damages the whole process. I'm hoping it doesn't, but I get what you're saying, that maybe this will make people less likely to be jurors if we've got to, interview every juror, or if every verdict is going to be scrutinized after the fact, or people are going to call jurors names. I agree with you. But if you're doing your job and you're ethical and you're doing the right thing, I don't think you have that fear. So I hope it just suppresses and keeps away people with, grandiose ideas of writing books and becoming famous by doing something unethical behind closed door in a courthouse. That's my hope. Netwoman, thank you for this super chat. How come there wasn't jury misconduct on Darren Chauvin case? I remember a jury member on that case was from the BLM and was bragging about how he made sure to get on the case and participated in marches, wearing a shirt, get your knee off my neck. Thank you for the discussion on this with a thorough breakdown of the totality of the case. Hope pickleball was fun. It was, but my feet hurt a little bit. I'm breaking in the shoes. Once they're broken in, I'll give my full review because I love them. Love the way they look and feel. But here's what I'll say about Derek Chauvin's case. My overall answer will be I don't know. I didn't fully cover that trial, and I don't remember this specifically, but I will say, if that's true, it's kind of like Runaway Jury, the movie. If you force your way on a case to make sure the outcome happens, that's juror misconduct. That's almost per se reversible. and overturnable as far as the verdict goes. So I don't know how much information they had on that, but to me, that seems impossible to say that that was a fair jury or a fair verdict, if this is the case. Regardless of who you believe is right or wrong or whatever, if you agree with the marches or not or whatever, if somebody goes into any case saying, I want to make sure this outcome happens regardless of what comes out in trial because of what I know before even becoming a juror, that's a no-no. That can't happen. JMB, Peter, thank you for your unbiased commentary and always deferring to innocent until proven guilty. Also, where did you get that cool shirt asking for a friend? I honestly have no idea. I have no idea where I got it from, but I can check out and let you know. My wife probably got it for me. Amber, judge told jurors in knocking neighbor trial they could not have Apple Watch during deliberations. I think the same thing that's definitely happened in cases we've watched. I can't remember if this one specifically. Rebecca said personal integrity is sad nowadays. Well, I hope we can promote it. I hope we can raise it up. I hope we can ask for it and hope for it and do it ourselves. And everybody that watches these and participates in these, hopefully we can do it. And we can hit the bad apples so that less people are like that, right? I think that's one of the important things of discussing this. Request to keep son stable mentally. Juror 15 was also responding in another petition for injunction. Domestic violence, ex-husband, protection on behalf of their minor child. He attached the petition. So all this stuff is public documents they have. So that's why I feel pretty confident that this information is out there. Juror 15 picked up his son, meaning the ex-husband's son, by the arm, slammed him against the wall. Minor child was visiting, expressed he was afraid to go home. Report of child abuse. Juror 15's boyfriend threatened to hunt the ex down and hurt him. Ongoing investigation by CPS. The ex-husband was seeking custody. Minor child was showing signs of being violent. Okay, so those are all the allegations, right, that are out there. And whether true or not, we don't know, but definitely something that should have been disclosed and dug into if the attorneys had more information. And another question people commonly have. What if jurors don't want to talk about this private personal information? Well, here's what they do. They say, Judge, I don't want to talk about it. Can I come up? Can we discuss something at, sidebar? And they can say, I have some stuff in my past that deals with DV. I don't want to get into it, but I wouldn't be a good juror here. That would be enough. And they'd probably be let off the case. And none of these details would be public. Juror 15's failure to reveal this information during voir dire amounts to juror misconduct and subjects the verdict to legal challenge, entitling Benefield to a new trial. I agree. This motion is filed within 10-day period prescribed by Rule 3.575. Given the nature of the alleged misconduct, Ms. Benefield asserts that there is reason to believe the verdict is subject to legal challenge on multiple grounds, including but not limited to juror misconduct, introduction of extraneous prejudicial information, influences external to the evidence presented during the trial, may have influenced the verdict, violation of jury sequestration, violation of the defendant's 6th and 14th Amendment rights, jurors potentially receiving the evidence outside the court proceedings to the detriment of the defendant's substantial rights. Now, I don't know how much of that is true, right? How much of that they're assuming, but I know that not disclosing that very pertinent and important and relevant information, I couldn't live with myself as a lawyer, right? That's the stuff that keeps us up at night. That's what gives us heartburn. It's not getting up and speaking in front of people, right? It's that somebody's looking us in the eye and lying to us. And some people say that's rich. That's ironic because lawyers stand there and lie to people all the time, right? And there are bad apples that do that. And I get it. The integrity of the judicial process and Ms. Benefield's constitutional rights are at stake. This court has both the authority and the responsibility to investigate this matter fully, including granting permission to interview all jurors who are served on this case, and then he lists out the jurors. Benefield requests this court grant permission to interview the jurors, expeditiously set a time and place for the interview to be conducted in the presence of the court and the parties, summons the jurors to appear at the time and place set forth for the interviews, grant any other relief the court deems proper and just. So I think they should grant an interview with Juror 15, dig in, see if it's true, see why they did it. In the Glenn Maxwell case, very similar to this, being a victim in the past, not disclosing it, very similar to what the victims went through in that case. And the judge brought him in, did an interview, judge asked the questions, federal court, so different ballgame. He was like, it was a mistake, my bad. And the judge was like, okay, no new trial. So if that's what this juror says, maybe they say no new trial. If it was intentional and like a net woman said she believes happened on the Derek Chauvin case, I think they should grant a new trial if this person knowingly misrepresented information and ended up on the jury because of that. This is like the exact, if you were a victim of DUI, okay, and you did not disclose that on this jury, and you end up getting picked for this jury in Ashley Benefield's case, is that an issue? Yes. Should we discuss it? Yes. Is it potential misconduct? Yes. But should it be enough for a new trial? Would it have overturned the verdict? Would things be different? I don't know. It's a different situation. But this being so on point to me is tough. I hate this. I hate this. I hate that this happened. The first part, I don't know if it's true or not. If it's true, let's dig in. If it's not, I think it's hard to prove that that's true. And I don't think that's enough to interview all these jurors, bring them back in and interview it because of, that hoodie guy. But let me know. What do you guys think about that information in the Ashley Benefield case? Now we're going to kind of switch gears and talk about the potential juror misconduct, clerk misconduct in Murdaugh's case. Okay? But before I do, let me answer a couple questions. 37 Cooper, did Chick-fil-A pay you? I'm hungry now. No, they didn't, but it is so good. Had it for lunch today. Rebecca, I wish more people would watch this channel, which is why I donate memberships. Sadly, it's more prevalent. Well, Rebecca, I can't thank you enough for it. I appreciate, all your questions and comments and gifting memberships. But I think we just got to do our part and do the best we can and never stop doing the best we can, right? Not give up and think it's not worth it. Just keep doing the best we can. And she just gifted 10 more Lawyer memberships. And I see in my stream, even more are coming. So make sure you have the gifted membership things turned on. And now let's get to Murdaugh. Okay. So Alec Murdaugh, accused of juror misconduct, and Becky Hill, the clerk of court, getting with certain jurors, talking to certain jurors, making comments to certain jurors. Watch the defense. They're going to try to trick you. Watch the body language, fake crying, whatever it may be. Don't trust the defense. Absolutely negative things. And we said after all of that, that if most appeals have a less than 10% chance of winning, this one had more like a 30 to 50% chance. Okay. Which is high when it comes to appeal, low to basically everything else, right? It's like if I only had a 30% chance of, winning something, I wouldn't feel great about it. But as far as appeals go, that's a pretty good chance. And there are two major issues and discussion points with the trial and after that we have focused on, we have agreed with the whole time. Not everybody agrees with me. When I say we, I mean me in this situation. Sometimes I mean we with the chat. But the two major issues are Becky Hill's conduct, which everybody agrees is a problem, and it's probably the biggest chance and reason it would get overturned and a new trial would happen, but also the financial information that came in a trial, the other bad acts. From the jump, when that was let in by Judge Newman, I didn't love it. I thought it was a bridge too far. I thought he let them get way too into it to prove motive, and the generally bad guy rule, everything piled on top, and there was no way Murdaugh was going to win. Now, I do think after hearing the jury interviews that if they do retry this again, there's a very good chance Murdaugh still gets convicted, because there are certain things like the big lie about not being down by the kennels, which was provably false in the Instagram video or the Snapchat, whatever it was. That's going to be near impossible to get over, but we don't litigate that now. It's not a question we have. The question we have right now is, should he get a new trial? Not what's the outcome going to be of the next trial. And some big bombshell news everybody was saying is that the Supreme Court of South Carolina has granted him an oral argument. Now, they can either, and if you go back and watch when I had Michael Ufferman on, who is Charlie Adelson's appellate lawyer and one of the best appellate lawyers in Florida, he described, what can happen with appeals, how they can just be, affirmed or denied or whatever without oral argument. That's kind of the quick and easy decisions. But when you're granted oral argument, that's a good first step, but that by no means means you're going to win. The majority of appeals still lose, even the ones that get oral argument. But in a case like this with at least one, maybe two really good arguments that they're allowing oral argument on, to me, pushes that percentage closer to 50-50 now rather than 10 or 30 or something below 50. I do think that Alec Murdaugh has a 50-50 shot of winning this appeal, which is about as good as you can get on appeal. Because I happen to read the case law and the rules in a similar fashion to his team versus the way the judge did and even the way the prosecutors do. Doesn't mean I'm right. I'm just saying that's the way I look at it, which is not always the case when it comes to appeals. Because once something happened and a verdict comes in, it's really hard to overturn that, obviously. But what I also think is an indication that he has a better than average chance of winning the appeal is what the people that hate Alec Murdaugh and have spent a good number of years fighting against him, what they're saying about it and what they've said about it. And so to give us a little illustration and something to watch and break down to together and react to together, I'm going to pull up a clip of from CourtTV. It's about a 9-minute interview with Eric Bland, who represented a bunch of victims against Alec Murdaugh, sued him, won a bunch of money, does press conferences, does all sorts of things, hammering Alec Murdaugh, snarky back and forth in legal documents with Murdaugh and his legal team. No love lost between these two groups. But even what he says, couched in a lot of the negativity, it'll give you an indication about how this appeal is a little different than your average. But first, I have a bunch of questions I want to get to. If the jurors are chosen from voter rolls, then if non-Americans are given the right to vote, then they can serve on a jury. Is this true? How has this happened? Not that I'm aware of. I don't think that's going to happen. I really don't think that's going to happen. David Reese, her allegations of DV was years after her ex-husband's and involved another man. She also bailed out her son who was arrested for DV. Those are the allegations, right? Was in jury selection for a child abuse case, and the judge told prospective jurors they could speak in private. Absolutely. We bend over backwards for jurors. We don't want to make anybody uncomfortable. We don't want to make anybody feel like they have to say something publicly. We don't want to embarrass anybody just because they got called for jury duty. In these instances, do jurors get charged with anything? Potentially, they could get charged with perjury, but more likely, I mean, we've seen a juror get sanctioned, right? We broke that video down. You can go check it out on YouTube, and they went to jail for what they did. So it's possible, but if it was a mistake, maybe nothing happens to the juror personally, but the trial could still get overturned and a new trial could happen. Anybody else concerned about Peter's blood pressure? Why? Because I'm so high strung. It is true. I am very high strung. Honey, do I like Murdaugh? No. Do I think he did it? Yes. Do I think he deserves a fair trial? Yes. Do I like Murdaugh? No. Do I think he did it? This crime? I don't know. Do I think he did the financial crimes? Yes. Does he deserve to be in prison for the rest of his life? Yes. Does he deserve a fair trial? Absolutely. If Becky said the things they're saying, isn't that jury tampering? Absolutely, in my opinion. I'm so angry that Murdaugh will probably get another trial. If he does, what Becky Hill did was forgivable, but still pisses me off. Absolutely, I agree. Pisses me off too. Do not insert yourself in this process. It just makes everything worse. Seems like juror misconduct is more and more prevalent nowadays. Do you think the YouTube channels, trials being aired on TV are all harming trials nowadays? A retrial seems like a waste of taxpayer money. So here's what I'll say. I know that this stuff happened before YouTube and before streaming, and it was much harder for people to care about it or to know about it or to want to see it change or to want to see it done right or to care about justice and a fair trial. So I think there are probably positives and negatives to it. Bad stuff still happens. If you shine a light and now we know about it, it doesn't make it more bad. It just makes it that we know about it. A few of the jurors said their decisions were altered by what Becky said. I think one of them said it may have potentially been altered. I can't remember. It's hard for me to remember back to that now. But I really appreciate Azam and Rebecca talking about my integrity. That always makes me feel good. I appreciate that very much. And giving others grace, keeping you. You deserve 500K by the end of the year. I don't know if we'll get there, but subscribe if you guys haven't already. We're working towards 500K slowly but surely. Let's get to this interview now. Let's watch this interview together of Eric Bland on CourtTV and see what his thoughts are now that Murdaugh has been granted a hearing. I'm sure he hopes he doesn't get a new trial. He hopes this verdict stays, but he's giving his honest opinion as a real lawyer who knows what he's doing. He's no dummy. He's no, joke. This guy knows what he's talking about. This guy practices law for real. He's a, personal injury civil attorney, does a lot of attorney misconduct. It's slipping my mind here. But malpractice, it's legal malpractice, which is one of the things he sued Alec Murdaugh for. But let's take a listen now to their discussion and we'll react to it.
This morning, we are turning the spotlight on Alec Murdaugh. The convicted killer will now get his day before the South Carolina Supreme Court, as the court has agreed to hear his appeal of his murder convictions for the killings of his wife, Maggie, and his youngest son, Paul. Now, his lawyers say that he deserves a new trial after jury tampering happened by the clerk of court, Becky Hill, who has denied the allegations.
Did you ever instruct the jury to watch him closely immediately before he testified, looking at his actions, looking at his movements? Did you ever tell a jury to do that?
No.
Did you ever tell the jury to pay attention to Mr. Murdaugh's testimony?
To pay attention, not specifically to his testimony. I did tell the jury to pay attention.
To what?
Just generally in the hallway when I was speaking.
Not to him.
No.
And again, we don't need to rehash stuff I've already done videos on and broken down. Like, you don't need to do that as the clerk of court. You don't need to, like, in the hallway when you're like the boss, tell the jury what to do. You don't need to do that. The judge will tell them, the lawyers will make a comment if they feel like the jurors aren't paying attention. Not your job.
Just any witness.
Right.
Murdaugh's defense team now has 30 days to file their brief. A hearing date for arguments has not yet been set. We have a great guest I want to bring in now. He has represented 4 of the jurors in this case and some of Alec Murdaugh's victims. Friend to CourtTV Network, attorney Eric Bland is with us. Good morning, Eric. Great to see you. Could we start, please, with your reaction to the news of the High Court granting his appeal?
Well, Alex and his attorneys always viewed themselves as the organ grinder and the courts as the monkey. But in this case, it's just an ordinary appeal that anybody would do once convicted of murder by a jury. So I'm not surprised that the appeal was taken. It's a little bit of a surprise that it didn't go through the Intermediate Court of Appeals first to get to the Supreme Court. But it's an important issue, the issue of juror interference. And it's going to come down to whether the South Carolina Supreme Court believes that Justice Toll, the former Chief Justice who heard the motion for a new trial, was correct when she ruled that not only do you have to show that there was a potential inappropriate comment or inappropriate conduct by the former clerk of court, but that it influenced their jury verdicts. The defense says that they should have applied the federal standard, which is all you have to show is the inappropriate communication or inappropriate conduct by Becky Hill, and you do not have to show the corresponding effect that it would have on the jury. There's also other appellate issues they're going to hear, which is the evidentiary issues on the financial crimes being admitted, and he claimed that the trial should have never taken place in Walterboro and he should have gotten a change of venue. But the clear constitutional issue is going to be on the standard applied by former Chief Justice. And if he loses in our Supreme Court, he's taking this all the way up. Alex has nothing but time. He'll be in jail for a prison for the rest of his life for the financial crimes that he was pled guilty to. So he has nothing but time, and this is going to be his recreation, which is burdening the legal system with continuing appeals.
Eric, curious what you...
Again, you hear the shots, not so subtle, that he's burdening the legal system with his continuous appeals. But at the same time, even you can tell in his voice, in his comments, in his statements, he knows that there are legitimate issues here. He knows what the question is. Of course, he agrees with former Chief Justice Toll. But everybody knows looking at this that this could go either way. This could absolutely go either way. Even some of his most staunch haters, and there's a lot of haters of Alec Murdaugh. I don't know anybody that likes Alec Murdaugh, right? Including myself. I'm not a big fan of him personally. But legitimate appellate questions I don't see as recreation to just burden the legal system. We've got to do things right. And I think Eric Bland would agree that legitimate appeals are necessary. They're not just a burden on the legal system. We have to have them. And if they should be overturned, it should be overturned.
I feel like the $1 million question. So many people who follow this case all around the world, I'm sure listeners to your podcast, Cup of Justice, have asked you, do you really think it's likely that the court could overturn his convictions? I mean, your legal opinion on how likely it is that...
So he could just be like, absolutely not, no shot. And he's going to do it later when they talk about a different appeal Alec Murdaugh is filing. He's going to be like, this is a bad argument. So contrast that. Remember what his answer is here. Focus up, pay attention, as Becky Hill would say. to his answer here, then we're going to compare it to his answer later when they talk about a different appeal.
That could happen.
It's probably very close. I believe he's guilty. I believe that there was overwhelming evidence, irrespective of the financial crimes. I think his behavior, his lies, the circumstantial evidence was strong of guilt. But for our system to work, it's got to work for the worst of us, not just the best of us. And Alex, even though he is the worst of us, is entitled to a fair and impartial trial. And if it is shown that this clerk of court tried to influence the jury for whatever reason, whether it was for a book or other reasons to see that he was guilty, and that Justice Toll should have applied the Supreme Court standard, then I would support the reversal. I think she did apply a correct standard, but in my career, if there's a United States Supreme Court on point, and somebody has a constitutional right to a fair and impartial jury under the Constitution, he may end up getting a new trial.
Wow.
You got to respect that answer. Again, regardless of what you feel about Alec Murdaugh, Becky Hill, Eric Bland, I don't care. I respect that answer. I really respect that answer. Okay. And I think he's right. I would think the Supreme Court decision on point may rule the day. He knows he's going to appeal it up to the Supreme Court if he has to. And this could go either way. Coming from a guy that has spent a lot of time and money and energy fighting Alec Murdaugh and proving how bad of a person he is. And he's won a lot against him. Even he gives it a pretty good shot. So that should tell you more than the Supreme Court giving him an oral argument on the hearing. The lawyers that look at this that are against Alec Murdaugh, that doesn't mean he's going to win. I'm not saying he's going to win. I'm just saying there's a lot better of a chance in this case than so many other appeals. That's what I want you to understand about this second half of our conversation today. When we're talking Alec Murdaugh, that's what's happening. That's what makes this different. The standard was up for interpretation, absolutely. And whenever that's the case, that's a pretty good appellate argument, because when everybody agrees the standard is something you're saying it is, or the opposite of what you're saying, which happens in so many appeals, it's like, nah, bro, you're going to lose that. That's not good. And we're going to hear that. So again, that's the answer I want you to keep in your head. And we're going to compare it to when they talk about his next appeal.
Eric, just to think about another trial happening, we know some of the biggest pieces of evidence would be introduced over again. The cell phone video from Paul's cell phone, arguably the key to the case. Let's look back at that clip together now.
Get back, get back. Quick, Cash. Quick. Hey, you got burgers now. Hey, Bubba. There's a guinea. There's a chicken. Come here, Cash. Cash. Quick.
And Eric, as we know, this video blew up his alibi. Unbeknownst to him, he was on that recording. I mean, this did it. If he were to get another trial, do you think we would see him still going with that alibi of I was at mom's house and I didn't do this?
He even if he doesn't, it'll be used against him. There's their prior admissions. Whether he goes forward with there was a different theory and continues to go with the two-shooter theory. Look, they've seen how the prosecution has tried their case. They will modify it a little bit. Maybe he won't go on the witness stand. He obviously did that at the advice given to him by his attorneys. So we would see possibly a different defense. I don't think we're going to see much of a different prosecution now. Whether Judge Newman is the trial judge coming back, if there's a new trial, I doubt he would be. Another judge may not let in all the financial crimes, but that video and his behavior after he called the police,
yeah, I'd be very interested to see what another judge does with the financial crimes. Well, obviously, if the appeal wins because of the financial crimes and that's in the appellate order, then the financial crimes aren't coming in. But if the judges are either silent on the financial crimes and they say, we don't have to get there because of this Miss Becky juror misconduct, we're going to overturn and grant a new trial, we're not going to make a decision on the financial crimes, then we don't know what's going to happen. But if they say, it's because of the financial crimes we're going to give him a new trial, that ain't coming in the second time around. But If they say, no, that was fine, they open the door, then will Murdaugh's team adjust to not open the door? Will the trial judge be like, well, appellate court already said it was fine to get into financial crime, so we're going to let you get into them? A lot is open for interpretation that could still happen here in this case.
10:07 p.m. and having totally clean clothes after claiming hugging and grabbing his son, who was full of blood and dirt. And all the admissions he made to the police officers during his first interview, I think he's going to get convicted again. But again, Julie, we need to have a system that's fair for the worst. And if Justice Toll applied the wrong standard, and it's proven that Becky Hill made statements that went beyond ministerial statements of what do you want for lunch, how do you get to and fro court, then he would get a new trial. But remember, there's only one witness who said that she said those statements. The 6 jurors I represent, not just 4, they testified and said they never heard her say anything other than ministerial comments. So will the court of Supreme Court believe one person over the other 11 who testified and said nothing untoward was said?
Oh, wow. That's a great point, Eric. That's a really great point. And of course, I'm in agreement with you. If his constitutional rights were violated, if his right to a fair trial was violated, absolutely, he deserves a fair trial. As you said, the system has to work for all of us, even the worst of us. And he is arguably the worst of us.
I mean, I love that comment. If it's going to work for the best of us, it's got to work for the worst of us, right? And hit the like button for that, right? We want the justice system to work for everybody. If you're a fan of justice, be a fan of this channel. Subscribe to the channel. Come hang out with us. Give us your comments, your thoughts. That's what's so important about learning about these systems here.
Us here in America. Eric, last question for you, please. We know that he's appealing.
So here is the other appeal on his financial crimes that he pled guilty to. We're not going to dig in a ton to it, but just listen to the different tone Eric Bland takes when discussing this appeal.
Arguably the worst of us here in America. Eric, last question for you, please. We know that he's appealing his federal financial crimes case after he pleaded. And I think that's puzzled a lot of people. You know, he pleaded, he got a 40-year sentence there, stealing from millions of his clients, some of those clients, you represent. He's saying that his sentence was 10 years more than the statutory recommendation and too harsh under the Constitution. That's his defense team's legal argument. What do you say to that?
I think it's just not a good argument. He pled guilty. He knew what he was pleading into. His attorney waived any arguments that were going to be made. The judge gave 45 days advance notice of an upward enhancement was going to be done. And his crime was so unique. I think it's not cruel and unusual under the 8th Amendment. I think the Fourth Circuit's going to reject it outright.
Eric Bland, always great having your legal.
So what do you think about this other appeal about his sentence that he pled guilty to? Boom, 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 boom. And I think he loses. They're going to reject it outright. That's how you answer when you're confident that your opponent and the guy you've been against so many times is going to lose. That's how you answer it. Not how he answered the first time, which I believe he was being honest and forthright and giving his honest legal opinion on both. But that should give you an idea of the difference between these two appeals and how real, like he's got a real shot, a 50-50 shot is a real shot on appeal to get a new trial. Carrie Ann said, Peter, I'm from South Africa and judges decide our cases. Do you think judges should decide cases in America because of all these jury issues? So here's what I'll say. Basically, every party has the opportunity to pick between a judge and a jury in criminal cases and in a lot of civil cases. Some are just bench trials, like family law cases or bench trials, things like that. The vast majority of people choose a jury trial. There's a million reasons for this. And at the end of the day, maybe people are saying they trust jurors, 6 to 12 people they don't know, over one person who maybe might be jaded or has a specific background as a lawyer or maybe has preconceived notions, or I don't know. But for the most part, people choose jury trials over bench trials. We have the option of both here in America. And that's the best. The freedom to have that option in our judicial system, I think, is what's so important. Bob Billy said golfing and pickleball in Florida, not a bad gig, my friend. I wish I could do more of it. And I hope one day soon I'll be able to, right? Bob Billy, how did the pickleball shoes play? Light. I was so fast, jumping so high, probably at least this high off the ground when I was slamming them. But they're new shoes, so they rub in some places. So I just got to get them used to it. I got to get them worn in. And full review coming later. Bethany, sorry, off topic. Don't apologize. No problemo. I know I'm the only one asking, but can you please look into the Ronnie J. Towns case It's been 10 years and he hasn't gone to trial. Shedding light on this case can help bring justice to B&J Runyon's family death penalty case. Okay, I will take a look at it. Here's what I like to do. People that request cases, I like to throw them out here just like you did to the chat. If you guys are interested, please let me know. Please let me know. And if enough people are interested and everybody wants to hear about a certain case, I'll take the time. I'll dig in. You guys know how I like to dig in deep, not just take a surface level when I do these long breakdowns. But I will say, I don't know if I want to announce anything on that yet. Some fun stuff could be coming in the future that would allow me to take a quicker look at more cases and scenarios, which a lot of people have asked. Some have actually asked me in my DMs, can we just do like a surface level look at some? My main thing is going to be this because I love digging deep, but there may be some opportunity for that in the future. We'll talk about. What's harsh is swindling all of people's money. 100% agree with you. And he deserves everything he got in the financial case. You're not going to hear me argue he got too many years in the financial case. I'll tell you that right now. Plenty of judges have had issues also, unfortunately. Judges are biased too. There are biased judges. There are good judges, right? Wafa Jones, question. It seems like juror misconduct is more and more prevalent nowadays. Do you think the YouTube channel's trial is being aired? A retrial seems like a waste of money. Okay, so I think this one already came up earlier. And we already answered it. I think that was kind of one of the main points of this entire video, right? One of the very important points of this video. Okay. That's all I got, folks. That's all I got. I appreciate you joining me. Happy Friday. I hope everybody has an amazing weekend. Please don't forget to hit that like button. And make sure you subscribe to our page because I'd love to have you guys be involved in our future conversations, future cases, whatever it is. I want you to be there. So that's all we got. Till next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.